Principals of Morrows. We've got Stephen Jelk, who's a specialist estate planning lawyer, and Alison Highland, who one of the managers in our wealth division that does a lot of work with aged care. We've, in the past couple of years, because of the age of the practice and the age of the clients, had a lot to do with the loss of testamentary capacity, or the loss of legal capacity. In corporate structures and people's business affairs, with their wills, they tend to, in some cases pretty poorly, take account of the death event. But historically, corporate structures and wills haven't really, not wills, but powers of attorney haven't addressed this loss of testamentary capacity. I went to an investment forum in Sydney, and one of the breakout sessions was from a specialist in dementia. And has anyone here ever seen that movie Outbreak, where the Ebola starts to spread through the US? Well, she actually did that, but it was the number of patients in the regions suffering from dementia. And it's a new disease. It can happen through disease, like the shrinking frontal lobe, or it can happen through accident, where you actually lose control of your affairs. And how does that interrelate with your personal affairs and your corporate and business affairs? So it's something that has been very neglected. In Victoria, it's a very expensive process to get on top of it. You've got to go to VCAT, and you could end up in the Office of the Public Advocate, which is an absolute nightmare. We had a client go through that process, and it cost in excess of $70,000. And the thing that scared me about that when we went through that process was that VCAT is a welfare organisation, so you don't have to be bloodlined or have an interest in the family to actually take the case to VCAT. Your next door neighbour could do it. You could say the family is mistreating this individual, and for $50 they're in VCAT and welcome to help. And if VCAT can't make the decision, you're off to the public advocate. And in this particular case, he had testamentary capacity or had legal capacity, but it was a bit inconclusive because he drifted in and out. And it took about 5 months in the Office of the Public Advocate to actually get a decision. So for a period of nearly a year, the whole business is in limbo, just meandering around. And it was pretty horrific in terms of the family situation and also the business situation. So I'll hand over to Stephen now, who will take you through this. We think this is really important, and it's very unscrutinised in documentation, but it's the sleeping giant. We'll take the questions at the end. We want to make it as interactive as possible, so if you've got any issues, questions, it'd be really good to sort of start the conversation. So I'll hand over to Steve.
Thanks, Murray. Stole some of my thunder along the way there, but thank you nonetheless. Okay, so as Murray said, I'm here to talk about legal capacity and importantly the loss of. The topic itself is designed to provide a summary of some of the critical issues surrounding the loss of legal capacity, but particularly I intend to answer the 4 questions that are up there at the moment. So what is the loss of legal capacity and its consequences? What are enduring powers of attorney and how can they help? What are the issues to be considered when an attorney is looking to exercise his or her discretion on interstate assets? And probably a big one, which deals with most of our clients, is what are the implications of the loss of legal capacity and the effect of enduring powers of attorney when dealing with companies and trusts? For most people, death and incapacity it's not a fun topic, it's not something they like to talk about, but it is an area in which professional advisors can provide substantial assistance. And Murray touched on it. A lot of people go to get advice for succession planning, but the professional advisors overlook the issues of loss of capacity. Most people consider death, but they fail to take into account the loss of legal capacity. So I'm going to go through some of the key points. I don't intend to give a full recital of the law regarding loss of capacity, but like I said, if you've got any questions, raise them at the end. We'll be happy to answer them as appropriate. Alright, so what is legal capacity? When you turn 18, you're considered an adult. and you're able to administer your own affairs. There's no single definition of legal capacity. It specifically depends on the type of the decision being contemplated or the transaction being undertaken. Generally, an individual is considered legally incapacitated, that is, they do not have legal capacity if they do not understand the nature and effect of their decisions or are unable to communicate them in some way. Communication is also a nice, very interesting word as well, and it's very subjective. It can be verbal, non-verbal, and the courts have had some commentary on this as well. So it can include written understanding, hand signals, blinking, etc. But when a court is required to determine whether a person has in fact lost legal capacity, the court asks itself whether the person concerned is capable of dealing in a reasonably competent fashion with the ordinary, routine affairs of mankind. That question needs to be answered on what we call an intellectual level. So does a person understand the nature and importance of their decisions, and importantly, do they appreciate the consequences of making those decisions? The question was revisited in the year 2000 by the Supreme Court of New South Wales, and in an attempt to further clarify, if you like, I don't think this quotation necessarily adds a lot of clarity, but it uses some very important key terminology in the assessment of legal capacity. So I'm going to read this verbatim. So it says, the ordinary affairs of mankind do not just mean being able to go to the bank and draw out housekeeping money. Most people's affairs are more complicated than that, and the ordinary affairs of mankind involve at least planning for the future, working out how one will feed oneself and one's family, and how one is going to generate income and look after capital. Accordingly, whilst one does not have to be a person who is capable of managing complex financial affairs, one has to go beyond managing merely household bills. So what does this mean? What does this actually tell us? That determining legal capacity is quite complex in itself. That legal capacity is decision specific. That a finding of incapacity in one area does not automatically mean the capacity is lacking in another. That capacity may be fluid, and that's something that Murray touched on as well. People can come in and out of capacity depending on the nature of their disorder, their circumstances, and the decisions that are being made. But despite the many different legal tests for capacity, there are some fundamental issues to consider. These are whether a person is able to understand the facts involved in the decision-making process and the main choices available for them. Are they able to weigh up the consequences of those decisions and understand how the consequences affect them? And importantly, are they able to communicate their decisions? And if you're concerned about a loved one or whether or not someone has lost legal capacity, you can get an assessment conducted. Lawyers, though, we're not capacity experts. In fact, we do everything we can to give people the benefit of the doubt. So what we look to do is we look to assist, depending on the nature of a decision or a transaction to be undertaken. We have some general tests that we employ when considering whether or not a client has capacity. But if we believe a person does understand and has the requisite capacity, we'll get them to sign up the transaction or the documents right then and there. If the question arises as to whether or not they fully understood the nature of their decisions, it's not up for us to determine, it's not up to a medical practitioner to determine, it's up for a court of law to determine. So what we try and do is we build a case in support of our assessment, and we keep those records for future purposes. Importantly, most lawyers will refer clients off to medical practitioners, or there's an aged care assessment service who can come out and do some assessments as well. But importantly, what if you are no longer able to manage your own affairs? How does the law see you? It sees you as a child at law. And if you have not formally appointed someone to act in your place, it's necessary to make an application to a guardianship or an administration board for an order concerning the appointment of a guardian or administrator. Now, I guess considering where we are, there's 3 separate jurisdictions. You've got Victoria, where we are currently, New South Wales and South Australia. It's a very similar process for each state. In Victoria, we have the VCAT, which is the Victorian Civil Administrative Tribunal. New South Wales, the NCAT, same thing, New South Wales Civil Administrative Tribunal. And in South Australia, you've got the SARCAT, which is the South Australian Civil Administrative Tribunal. But for all intents and purposes, it's the same process. It's just magnified out, different forms, different applications, but the decisions to be made are all the same. In Victoria, though, you're making an application for what we call a guardianship and administration order. And essentially, you're requesting the tribunal appoint a substitute decision maker. You're considered a child at law, you're unable to make decisions for yourself, and therefore the tribunal will determine whether or not a substitute decision maker is required. In order to do so, the tribunal asks a couple of questions. Is there a need to do so? Has the person in fact lost legal capacity? And, importantly, is it in that person's best interest to have somebody else appointed? As Murray touched on before, sometimes it is appropriate, but with respect to capacity, it's fluid, so it's not always a necessity. Each tribunal, Victoria, New South Wales and South Australia, have two different types of appointment, two distinct powers that they can use. First is for an administrator, that's someone to make financial or legal decisions on your behalf. The second is for a legal guardian, and that's for someone to make personal or lifestyle decisions. Very important though, and again Murray touched on this as well. Anybody can lodge an application for an administration order regarding the decision-making ability of an individual. Whilst most applications are made by concerned family members, because they're the ones that become aware of the loss of capacity, anybody can make the application. Your next door neighbour, the mailman, your next partner, for example, the options are quite varied. Similarly, the tribunal can appoint anybody as well. So anyone can be appointed. All they need to do is be willing to act on your behalf and there be no conflict of interest. If family members are unable to agree, the court will actually not try and determine, the tribunal will not try and determine who is more appropriate in the circumstances. They will simply say, you can't agree between yourselves, we're not going to determine who's appropriate, we'll appoint an independent third party. And that's where you end up with the Office of the Public Advocate or state trustees administering your affairs. And that's not in anyone's interest. So, what are your options? Well, you can take control yourselves. You can prepare powers of attorney before losing legal capacity and actually determine who can control or who will act on your behalf if you are ever to lose legal capacity. With respect to powers of attorney, there's a myriad of options. The legislation in Victoria has recently changed and has provided for some other types outside of these three. But these are the most important ones. When we're talking about the loss of legal capacity, we need to prepare an enduring power of attorney. And specifically that word enduring means the power conferred endures past the loss of legal capacity. So you can prepare these powers now, and you can actually monitor them, change them, revoke them at any stage up to losing legal capacity. However, if you do actually lose legal capacity, you won't be in a position to actually monitor the use of such power. As a general rule, all non-enduring powers of attorney are revoked upon loss of capacity, so they're torn up. And at death, your enduring powers of attorney are torn up as well. Your will becomes locked in the document. So there's various stages along the path when we're considering succession planning. All of the individual circumstances need to be considered. When preparing powers of attorney, there's various risks and considerations to be taken into account. Some of the powers are overlapping, so you've got your three powers up there, and there's actually some contradictory provisions in each of them, but the legislation, the pieces of legislation provide a hierarchy. The legislation governing each type of power of attorney is different in each state, but the powers conferred are essentially the same. They fall into those three categories. Importantly, get advice or assistance because the legislation does change. Recently in Victoria, September 15, legislation changed. In New South Wales, it was in 2013. But probably the biggest thing is the changes to legislation still enable previous powers to be effective. So there's what we call grandfathering provisions. Provided the powers were prepared correctly in the first instance, they will continue forever and a day until such time as they're revoked. But if they're not prepared correctly, obviously they're declared void on the changing to the legislation. Alright, the three types. For financial, we've got the powers conferred for financial matters include buying and selling real estate, shares and other assets on your behalf, the power to operate your bank account, the power to spend your money on your behalf, and also the power to bring and defend legal proceedings. So it's quite broad. There are some general exceptions. Your attorney can only act in your best interest. Your attorney cannot act where there's a conflict of interest, so where they're going to gain a benefit from acting on your behalf, they must refuse to act. Your attorney can't make a will, they can't vote in state or federal elections, and they can't institute divorce proceedings or respond to divorce proceedings on your behalf. You can then also actually provide for additional restrictions on that as well. So you can determine how far the gambit of powers actually operate. So for example, you can prevent your attorney from selling certain assets, or prevent them from lending money to family members, etc. But the point I'm trying to make is that general powers of attorney have some general parameters that they can be adapted to your individual circumstances and needs. But the first question needs to be asked is, what are your needs, what are your circumstances, and therefore what are your options? There are three occasions when financial powers of attorney can commence, either immediately upon you losing legal capacity, or upon the occurrence of another specific event, a date, an age, etc. You've got a few options regarding the appointment. So you can appoint multiple people or one person. You can appoint them jointly, which means that they must act together. Severally, which means they can act independently. Jointly and severally, meaning they can act together but also independently. And if you have a desire to appoint multiple people, you can actually have a majority. So where it's three or more, you can have a majority to make a decision on your behalf. Second type is guardianship. And guardianship deals with specifically personal or lifestyle decisions, where you can live, who you can spend time with. Guardianship powers only commence when you lose legal capacity. And similar to financial, you can restrict the powers conferred upon your relevant guardian as well. And same with financial, you have the similar options with respect to the appointment. You can appoint multiple people to act jointly, severally, by a majority, etc. With respect to enduring powers of attorney for medical treatment, you're authorising an individual to make decisions about appropriate medical treatment on your behalf, specifically when you're unable to make that decision for yourself. The term medical treatment is defined under the relevant legislation to mean an operation, the administration of a drug or other like substance, or any other medical procedure excluding palliative care. And palliative care is defined under the legislation to mean relief of pain, provision of food or water. So specifically, when you're not able to make a decision for yourself as to appropriate medical treatment, you can appoint someone to do that. An enduring power of attorney for medical treatment also gives your attorney the right to refuse medical treatment in certain circumstances. But with respect to all of these types of powers, the positions are the same across multiple jurisdictions. The types of powers conferred under each statute are very similar, even though their form is different. So what happens if you have a power of attorney prepared in Victoria and assets in New South Wales? Well, for Victoria, New South Wales and South Australia, so the three relevant jurisdictions in this specific location, there's a mutual recognition of powers of attorney validly prepared in other jurisdictions. So if it's prepared in Victoria correctly under the relevant legislation, it can be used in New South Wales. Vice versa, and South Australia is similar. Bear in mind it's not the same across the board in Australia, but specifically in this location it is. Similarly, in Australia we don't recognise foreign powers of attorney as well. The principle exists abroad, but the power needs to be prepared in this specific jurisdiction in order for it to be valid. What are the implications of loss of capacity for companies? You've got to take a step back in this circumstance. A company, pursuant to incorporation, is a separate legal entity, distinct from its shareholders and distinct from its office holders. A company is considered an individual at law, and unless its constitution specifically prohibits certain actions, has the same powers as an individual. In talking about constitutions though, every constitution is different. The Corporations Act establishes some replaceable rules under which companies can operate and can use. However, every constitution needs to be read and understood in order to fully understand and appreciate what happens if someone passes away or loses legal capacity. When we're talking about companies though, we've got a couple of distinct parties. So you've got your office holders, your controllers, your directors and secretary, and then you've got your shareholders as well. And the shareholders are those beneficially entitled. So when we're dealing with the office holders, if a director or a secretary loses legal capacity, they automatically vacate their office, the office that they hold. The Constitution, as I said, then determines what happens with respect to a replacement. If there's multiple directors, well then sometimes the other directors can appoint a replacement, or alternatively, shareholders will then have the right to call a members meeting and nominate a replacement as well. However, if you're the sole director, sole secretary, sole shareholder, things can get a little bit complicated and a little bit difficult. If you've got an enduring power of attorney in place, it's fine. Your attorney can call a meeting and can appoint an alternate as a shareholder and as a director. However, if you don't have an enduring power of attorney, the company can be frozen and you need to toddle off to the VCAT, or whichever tribunal, depending on the relevant state, and have a determination and essentially have an administrator appointed. And that person will step into the role, your role as shareholder, and may be able to nominate a replacement director as well. So the point to take away is each company is different and needs to be assessed individually. The structure of an individual company may be unique, but planning now can avoid potential issues in the future. Once you know your options available, then you can obviously consider those, make some plans and move forward. When dealing with family businesses, you need to consider many different things. One thing I mentioned before was that an attorney cannot act where a conflict of interest exists. So you need to be careful appointing an attorney who then you would like to be the subsequent director of the proprietary limited company. There's a conflict of interest. The question is, can they appoint themselves where they're gaining a benefit? Generally the answer to that question is no. So therefore, which family member is to take over? Who should be your attorney? And importantly, is your attorney going to follow through with your wishes and make sure the right person is appointed? A couple of options when we're dealing with small businesses or family companies. Shareholders agreements, family constitution, succession plan, powers of attorney, or a mixture of all, can be a good way to essentially deal with the potential unforeseen circumstances. Then, what happens when a company is acting as a corporate trustee? So with a generic or a general discretionary trust, you've got a couple of roles. You've got the settler, and the settler's role was to make the initial gift into the trust in order to establish the trust. You've got the trustee, whose role it is to determine the day-to-day operations of the trust. A guardian is the person from whom a trustee may need to seek permission in order to exercise certain trustee powers. Or you've got an appointer, and that's where the ultimate control sits, is with the appointer. It's the person or entity with the power to remove the trustee and appoint a replacement. So that's the most important one. And what we'll focus on is when we're dealing with succession planning is transfer of the trustee and also the transfer of the appointer. Okay, a couple of types of trustee, generally, proprietary limited company or an individual. And the structure is a little bit different for both of them. With a corporation, so with a proprietary limited company, it's the same as I've just discussed before. The Constitution determines what occurs. The director will be removed in the event of a loss of capacity. The remaining directors, if any, will be able to appoint a replacement. Failing that, the shareholders or the attorney of the shareholders will be able to appoint a replacement director. However, if you're a sole shareholder, again, the attorney can act, or if no power of attorney is in existence, you're off to the tribunal. If you're an individual trustee, your powers of attorney do not confer the authority, do not enable an attorney to act as a trustee. Other arrangements need to be contemplated. The trustee will usually contemplate what happens if an individual trustee is to be incapacitated, and may, you say may, commonly, it'll confer it'll transfer the power of the trustee through the power of attorney. So if you prepare a power of attorney, your attorney will likely be able to act as your trustee, provided the deed provides for it. It's not always the case. Alternatively, we can prepare a deed of succession or a variation to the trustee. But more importantly, rather than dealing with a trustee, we look to deal with the appointor. And the appointor can actually remove the trustee and appoint a replacement. So that's where the ultimate control vests. Trust deed's the starting point. The deed may contemplate what is to occur in the event of the incapacity of an appointor. Couple of options. We can prepare a deed of succession or a variation to the original trust deed. However, if you do nothing and you do have a power of attorney in place, there is some case law that actually allows your attorney to step into the shoes of an appointor and act on your behalf, remove the trustee, appoint a replacement, and move forward on that basis. The issues when we're dealing with companies and trusts is that most companies or trusts are off-the-shelf variety, meaning they've been established for some very general purposes that are used on a day-to-day basis across the board. They suit everybody, if you like. For this reason, every situation is different. You need to look at your current documents, understand what your current options are, understand your individual family circumstances, and appreciate what your intentions are moving forward, and then they can be documented. But until you actually understand what's currently in place, you can't make any decisions moving forward. For this reason, it can be a lot of work. That's all I can say. You need to read all of the documents, give you some advice as to what your options are, and then you can move forward and make some decisions after that. What do you actually achieve from succession planning? What do you get from planning for the unknown? Peace of mind, that's probably the biggest thing. People work their whole lives for whatever reason, to generate assets, generate wealth. They often receive great structuring advice from their financial advisors or accountants, but they've not considered what happens in the event to that structure at the end of their working lives. And this is where succession planning comes in. Whether it's spoken or not, everyone has an intention. What we do is we actually have those discussions, ask those questions in order to bring those intentions out, and assist what we call a smooth transition. That's what this whole process is about. It's about ensuring transition and control can actually take place. It's more than just having a will. When we do succession planning, we look at hypothetical situations with a view to ensuring, again, transfer of control. The benefits of good succession planning probably won't be realised for many years, and most likely the person in control will never actually see the benefits themselves. It's about, if something were to happen, transferring that control and that succession through the generations. The most important thing I'd probably like to stress to people to take home tonight is the fact that every structure is different. Every family is different. What works for one may not work for another. The point is to ask the right questions, have the right conversations, and understand the intentions in order to be proactive in the unforeseen. That's it. And usually you're looking about 3 months to get a hearing.
Even if it's urgent, you can't pump
That is
yourself up.
urgent.
It's crazy.
What happened in the case that we ran, there was a pretty successful business in Melbourne. They were the market leader in providing a service to the building industry. There was a daughter that worked as an operations manager in the business in Melbourne, and there was the father that had the shrinking frontal lobe. So, you know, some days he was good, some days he was bad, and you know, he's going to lose testamentary capacity. It was a question of it. He had a daughter that ran a very similar company in Queensland, and in 36 years of practicing, her boyfriend was the craziest, rudest, most erratic, dangerous person I've ever met. He was an absolute lunatic. And their intentions weren't good. The business, because it wasn't getting 100% of the attention wasn't going fantastically, it was going okay. And the boyfriend in Queensland, for $50, tried to get his girlfriend appointed to run the trust. Right? For $50. So their legal costs were $50. The daughter-in-law, and of course, for different reasons, both daughters had different opinions as to what should happen. They each thought that they could run the business better. And it's the typical family dynamic that changes when the person that is the glue to the family can't do it. And so it ended up in the office of the public advocate, and it took months. I reckon it took 14 months, where they were in limbo, so that everything was gridlocked. But if you had an enduring power of attorney, you could take control of the situation. And in that particular case, this individual's brother, who was independent to the family, was anointed to do it. But they contested the appointment on the basis of loss of testamentary capacity. But it's one road accident away. Whoever you're going to give that power of appointment to, pretty important person, because they can call the shots. So you don't want to give it to someone you like, you want to give it to someone that's got some financial acumen that's prepared to do it. So you might want to give the guardianship to a family member, for example, to look after the welfare aspects, and do the financial stuff to someone that's a bit more experienced with it. But we're seeing it more and more and more and more, where some members of the family have no idea of the business affairs, and then there's an event and they're left high and dry. And Alison sees it a lot in the aged care space, where people go into a home, and when they go in they're fine, and then if they lose that testamentary capacity and you haven't got that guardianship and you're in dispute with the aged care home, you've got all sorts of strife. Right? So it's very important that, I reckon the power of attorneys are more important than a will, actually, because if you have a death event, you haven't really got a problem, but you're still around when some of these events happen. So the powers of attorney, I think, are pretty important.
And it can be done well and it can be done poorly as well. So the fact is, if you've got something in place, there's usually something that we can work with. If you've got nothing in place, that's where you end up in the VCAT, and you end up going for a very long time with a lot of uncertainty associated with it. So something is always better than nothing. Whether or not it's brilliant is another question altogether. But actually speaking to a lawyer, speaking to your financial advisors or the like, and just going through the decision-making process, understanding what your options are. And like I said, something is always better than nothing. End up in the tribunal, because what happens is, with respect to joint and several, they can act independently of each other until such time as they have a dispute. When they can't agree, they need to both cease to act and then try and mediate the situation. If they can't determine it yet, someone else needs to make that decision for them. And at that stage, the tribunal will actually determine whether or not they're fit and proper people to fulfil the role as an attorney, and then likely removed as well. So it's a very important decision to be made. Again, it may not ever be used. That's the other aspect of it. It might be many years before you receive the benefit, or you may never receive the benefit other than peace of mind, sleeping at night, knowing that at least the person that you want to take control, if something were to happen, it will be the person that will take control.
You can do this off the internet, but that's not the skill. The skill is in the advisor asking you the questions that you have to answer. You know, whether they're appropriate. What's appropriate mean? Well, some of those probing questions with a few examples, you can make the value judgment as to whether, one, that individual wants to do it, and two, whether there's enough trust and enough capability to do it. That's the hard part. You know, getting the right person. There was an adopted son and a bloodline son, and the adopted son had control of the powers of attorney over mum's affairs, and he had a business that was going bad, so he decided he'd take a pre-inheritance. Because the business was going worse, he took a bit more pre-inheritance, there was basically nothing left. And when it finally happened, the money was gone. Pretty hard to get it back if it's gone. So the appointment of that individual to look after the financial affairs, you're actually giving them the checkbook. And it's probably more important In the guardianship space, we had an individual that was in a very bad car accident and ended up in Rosebud Hospital. Now, you don't want to be in the Rosebud Hospital, full stop, right? But, one family member lived Frankston Way and the other one lived Eltham Way, so they wanted to shift them, and they wanted it so that they could go and see them and be close to them and those sorts of things. Well, it ended up in World War III, because when you get these events, what tends to happen is people honestly and genuinely believe that they're right. Yeah. Right? Like Mum, the death event, Mum said I could have the wedding rings. Well, she told me that too. It's on. So very important that you consider who is the most appropriate person to take control of it. In some cases, you might want an independent in there. You might want the accountant in there, for example, to assist the family with the financial affairs, and you might want a brother and a sibling to be associated with the care aspects.
Or a different person to work for the family company versus the family trust. Yeah. You do have all of the options under the sun. With respect to powers of attorney, you can appoint anybody to be a controller. And we can make them as broad or as specific as need be. But it's about understanding what the individual circumstances are and going through the benefit analysis. Who do you want to be in control and making sure it actually follows. So what happens in the event of your death? Powers of attorney are inoperative. Your will is the operative document. Now, are you talking about children under the age of 18? Or
No, I'm a choice would be.
okay. If you pass without a will and you've got adult children or a wife, there's some rules in the relevant legislation that say what is to occur. And if you don't have a will, the person with the greatest claim to your estate is the person who needs to make an application to gain title to everything. In the event of your death, and you don't have a will, married with children, your wife gets the first 100 in Victoria. Your wife gets the first $100,000 after payment of all of your funeral expenses, tax debts, etc. Your wife then gets 1/3 of the balance remaining. Your surviving children get the remaining 2/3, divided between however many children you actually have. So, your will is a very important document, specifically if your intentions are outside what the legislation says. And the legislation is not a good example. It's an attempt for equality, but it creates a lot of problems associated with that as well, particularly where there's minor children involved. So, but powers of attorney operate whilst you're alive. When you pass away, your will becomes the operative document. If you don't have a will, then the legislation determines what happens.
He was an accountant, had his own practice, and he was one of 8 kids, which is unusual in my age group, right? And the father had the house in his name, which was pretty typical post-war, right? And so Mum wasn't on the title, and he died without a will. And so Mum got the first 100,000, and then the rest of the assets which were in his name were divided up against the 8 kids. But it was a dysfunctional family. Some of them were on drugs, some of them were hopeless, and they wanted the money. So my mate literally had to buy his brothers and sisters' interest in Mum's house so Mum could stay in the house. You don't reckon that's a trauma? So he actually had to stump up to pay out the other people, because they basically, it was like the Clampets, so warring. And they thought it was a windfall, and they didn't give a toss where Mum was, right? And he had to go back and buy his brothers and sisters out, not all of them, but he was the one that had the money, out of the family home.
And a lot of people say it's never going to happen, but no one has a crystal ball. And that's probably the point of going through a process like this, is just running through the scenarios, running through the questions and taking control. Probably with respect to your appointor, if you've got an enduring power of attorney in place, that is as broad as the legislation allows you to, which is pretty standard within the industry. Whomever you appoint as your attorney will take control of your family trust, boot out the trustee, appoint whomever they like, if required, and they will take control of all of your wealth that's tidied up in there. So, very important. Your trustee will determine the default position, but if your trustee is silent, your attorney will likely have the power.
That's probably more important because your estate is only assets in your name.
Yeah.
And so if there's this thing called a Part 4 claim, which is interested parties can make a claim back against the estate to get their fair share of the assets in the estate. But if it's in a trust, and the asset's in a trust, it's not personally held, so it's like what's in super. It's outside of the estate, so that the power, there's plenty of cases where someone stepped into the shoes as a pointer and made 100% distribution back to them and cut everyone else out. Not a lot you can do, because it's a discretionary trust. It's not a breach of trust because it's a discretion. If it's a unit trust, it's different. But it's got to flow proportionally to the units. So you see this a lot in, say, farming communities, where there's, you know, the family home and farm is held in a trust, and you think, oh, I'm going to split that up amongst the family and do whatever else, but it's actually got nothing to do with the will. So it's important that that control of that appoint order is critical, and it's even more critical if you lose that testamentary capacity, where you have a road accident and you actually can't carry on. What's going to happen? You know, is someone going to take it over, or who's going to step into those shoes and make the decisions you'd expect to be made under the circumstances?
But there are some options that you can use and some ways that you can mitigate the risks as well. Multiple legal appointed, professional advisors requiring joint decisions only, etc. So there's ways you can mitigate the risk, but there's always going to be a risk, unfortunately, because of the nature of the structure itself.
It becomes about 1,000% more complicated if you've got two business partners that are in joint ventures, unit trust partnerships. If something happens to one of them, they probably want the asset out in cash, for example, but there's a cost to the business doing that, and so there isn't a meeting of minds anymore. So it could be dealing with the delinquent daughter who just wants cash, or son. So that as soon as one of these things happen, there's a change in that dynamic and that family relationship that we see all the time, and it becomes pretty expensive and unwieldy exercise to try to get some resolution within a reasonable time frame. And it's probably really frustrating in that loss of testamentary capacity, because the individual's still around and it's still lingering. It's not just clean and gone and you're starting to move forward. And people's beliefs are usually pretty genuine, but they're different. Right? They just want to do different things for different reasons. We see it all the time. And it happens, you know, people go into business arrangements with other people, and then something will happen and the total dynamic changes, and the conflict of interest and what they want to do is very reasonable from their point of view, but it's got consequences. Probably, you know, in vineyards and farms you see it all the time, where it's usually not that well documented. The corporate structure was done years and years and years ago, never been reviewed, really don't know what's in there, probably doesn't even handle the death events very well, because it wasn't something that was considered 20, 30, 40 years ago. It just
something you've inherited from previous generations as well, and it's what you like,
taken
and
it
it's
over,
what you're stuck with, and trying to understand what your options are.
see, trusts, discretionary trusts really are only used as tax vehicles mid-70s, right? And they were a new invention. So people went from partnerships to trust because of distributions to tax, but there was never any contemplation of death or loss of testamentary capacity in those days. It was just tax driven. So that they were built as a tax vehicle. They weren't built for that intergenerational transfer that was going to happen 30 years down the track.
Tom?
Legislation won't change substantially. I think those positions are pretty clear, but we work pretty hard to come up with some weird and wonderful creations on occasion, depending on what clients' desires are.
Yeah.
To explain, we're advisors, I guess is the easiest way to describe our role, is to give you an understanding as to what your options are. We don't get to make decisions, we just talk about the pros and cons of different circumstances and give you the information you need to make an informed decision. That's the role.
The legislative structure has got less chance of changing than the family dynamic. your kids get married or divorced or grandkids appear or things happen. So that it's making sure that the family dynamic and what you want to happen fits the structure. And the longer that goes without revision, the more it'll drift.
Yeah. And on occasion we work on that side of things as well. So it's about driving the family dynamic and the family culture down a certain path. And by doing that, you can actually resolve a lot of the issues without changing your structure at all. It's just about designing the family, coming up with some ideas and some philosophies that everyone can live by and drive the wealth for generations. Sometimes that's sufficient. But you may not be able to change the structure that you've actually got in place for various reasons. So you do your best in all of the circumstances. But what works for one person doesn't always work for everybody else. With respect to your joint accounts, if that's what your assets are, if you've got jointly held assets, etc., the other account holder can generally deal with those assets. But when it comes to selling shares, selling real estate, cancelling a telephone account, all of the other gambit of options that you can do personally yourself, at law and financially, that's where the value of powers of attorney come from. So one of the points I was trying to make earlier is you may not ever see the benefit of the document, but you'll get the peace of mind saying if something were to happen, there is a check and balance in place that says this is the person that I authorise to do things for me. But with respect to financial, you can appoint your husband now to step into your shoes and do anything you can ordinarily do yourself.
Okay.
Specifically for financial purposes. The guardianship and the medical treatment, no, not at all. You have to wait until a later date.
Okay.
Exactly right. So with respect to financial, yes, the two layers.
Okay.
Immediately, so the first layer, one person or multiple people, and then the alternate layer as well, one person or multiple people.
Okay,
For financial, yes. Medical treatment, one and one. Guardianship, multiple and multiple.
Okay.
So when we go through the planning process, there's no point doing it if you don't do it well. So we always try and discuss those options. Sometimes people can't think of a suitable alternate, and I'll say, well, if that occasion occurs, then I'll come back and I'll re-prepare the documents. But in my opinion, they'll never come back.
No.
Plan for it. If it doesn't happen, fine. At least you've got the peace of mind of knowing that you've gone through the decision making
Right.
process.
Okay. Yeah, I think we've got that.
You should talk to whoever you're going to anoint because they've got to be willing to do it.
Yeah, they might refuse to make a decision. That's the other aspect. So
Yeah.
the document's not worth the paper it's written on if the person refuses to amend that.
Yep.
I had a client the other day who intended to appoint her two children. He sent it out to her daughter, sent it out to the son. Turns out in the time when she signed and her son signed, the whole family had a falling out. They never had the discussion about appropriateness of that, so we had to start all over again. So have the discussion. You'll save a lot of time and suffering too.
Yeah.
It's always good to be open, I think. I know it's a difficult topic. It's not great, but
It's upsetting sometimes.
well, that's it. But your advisors will be happy to walk you through the process, and it is upsetting. But it's more upsetting when you don't have those things in place when the unforeseen does actually occur. With respect to loss of capacity, as an individual trustee, the legislation itself, and this is something we're dealing with at the moment actually, the legislation itself, depending on the way in which the power is prepared, will determine whether or not that attorney can step in and act as a trustee. There's a provision under the Trustee Act in Victoria that says it needs to be contemplated. You can confer the authority, but if you haven't prepared the power of attorney appropriately in the first instance, well then no, they can't step into the shoes and act as trustee. With self-managed superannuation funds, there's all of the regulatory framework as well. So the parties need to be suitably represented in the structure.
You can't establish a self-managed super fund with a power of attorney, okay? But if it's established and something happens, if it's well crafted, the power of attorney, you can step into the shoes and continue it.
It's better to have
You
full
can't do the
trustee
establishment
process.
first. Because a power of attorney can't act in a trustee capacity, you can take it over.
But with respect to self-managed funds, it's a lot easier if you've got a corporate trustee in those circumstances.
Well, you can just get rid of one director and make it a single, just come back to me.
Okay.
Thank you for coming. I hope you got some value out of it, and if you need any further assistance, ask your advisors here. I'm sure they're excellent at their job. So, And if you need some legal advice as well, feel free to ask for our details, and we'll be happy to assist.
And be very careful till you get the paperwork in place.
I reckon